Welcome to Planning Ahead with CMS.
In this part 3 of our series on renewable energy, I'm going to hand over to my colleague Rob Garden, who's going to talk to you about how you can prevent your development consent order being challenged in the courts, and also how to avoid your application being refused. Over to you, Rob.
In this episode, I'll be talking through the various ways in which you can minimise the risk of refusal or legal challenge for a renewable scheme, focusing on 3 key areas. The building blocks for a successful consent, then looking at legal challenge trends, and finally some common challenges you might face. In terms of the building blocks for success, there are 4 kind of key building blocks I wanted to talk through. The first is consultation, and ensuring not only that you follow procedure, but also increasingly that the substance of your consultation is fair given increased public scrutiny. And considering those principles of fair consultation from the outset, making sure you engage with the public at an early stage. Secondly, looking at environmental impact assessment and increasingly habitats regulation assessment. For habitats derogation cases, consider preparing those on a without prejudice basis, and particularly considering the need for mitigation and compensation at a project inception stage. Thirdly, looking at land, and particularly if your project is going to be underpinned by compulsory purchase powers, ensuring you've got optioneering and alternatives considered throughout will be increasingly important. And then fourthly, really positively, building a positive case for your project, looking at the needs case, setting out the need for your development in your location, and increasingly, again, identifying the benefits that can be attached to your project so they can be weighed in any decision. In terms of the trends for legal challenge, both in terms of renewable energy generally, but nationally significant infrastructure projects increasingly, they're increasingly subject to challenge. Part of the reason for this in the renewable energy space is that the suite of energy national policy statements are now 12 years old, so the designation of new policy statements is crucial. The current policy gap leaves an area for challenge. And a further reason, and we'll touch on this in some of the common challenges, is just that GB is a small island and space is limited, and as such, communities, particularly coastal communities, may well feel overburdened by development. So the final piece, looking at common challenges that we're seeing, alternatives is increasingly a ground of challenge for local communities and action groups. And we've seen that with the East Anglia offshore wind farms in the High Court case of substation action Savey Suffolk against the Secretary of State. That case looks at alternatives and summarises the law as set out by Mr. Justice Holgate in the Stonehenge case, also from 2022, and essentially reiterates that a consideration of alternative locations for development may be necessary in exceptional circumstances, such as where there are clear planning objections and significant adverse effects with the development. Ultimately, there's no one-size-fits-all approach to this, but generally the greater the harm, the greater the obligation to consider alternatives. And the obligation will be greater where there are alternative options available and identified. That doesn't mean all alternatives need to be considered, and those which are vague or unlikely to come forward may attract limited weight. But ultimately, the case law is a question of whether alternatives must be considered. It's fact sensitive and within the planning judgment of the decision maker. A decision maker is only going to have to take those alternatives into account and where it's obviously material to do so, such as where there is harm. Another recent decision on alternatives that's important is the Aquin decision from January 2023. And that was a case where the promoter actually successfully challenged the refusal of an application based on alternatives. And the key things to take away from this are essentially to ensure that you're fully capturing your reasons for dismissing alternatives, that you're reporting that in your application documents, and that you're also back-checking that at each stage of the project, so that you're going back, keeping decisions under review, and ultimately recording that process as part of your application process. A second and linked ground of common challenge that we're seeing is cumulative assessment. And again, a case from February 2021 in relation to the Norfolk Vanguard and Boreas offshore wind farms, the case of Pierce, demonstrated the failure to have regard to cumulative effects can lead to a refusal of the DCO. In that case, the Secretary of State had information in front of him to reach a decision on cumulative effects, but did not do so. And the court ruled that was unlawful and actually quashed the DCOs. This obviously depends on the status of the projects that you're assessing cumulatively. And again, the East Anglia offshore wind farm case that I mentioned earlier, in that case, there were 2 projects coming forward which were at an early stage and where environmental information wasn't in front of the Secretary of State. And in that case, it was held that cumulative assessment was not necessary to be undertaken. So that summarises kind of where we are with challenges to projects, some of those common challenges and how you can look to address those. Thank you for watching, and if you have any questions in relation to legal challenges in the renewable energy space, please feel free to get in touch with me or any member of the planning team at CMS. Thank you.